Good afternoon, ladies and gentlemen. It's my pleasure to be here and to have the opportunity to, let's say, conclude the conference. It's my pleasure to give you the final presentation. How does it work? Can this big one? Yeah. I'm going to speak. I'm going to present my paper on the rights of the child in private law and give you idea how the child is protected within the legal regulation in the Czech Republic. And here you can see how my country report looks like. I tried to concentrate on the definition of the child, then the civil status of the child, which is quite a complicated issue, then a family status on the child, and especially on the protection of the child by the concept of parental responsibility. Then the special attention was paid to the property rights of the child, including maintenance duty, hereditary law, and so on. And special attention was paid to personality law, healthcare law, labor law, commercial law, and so on. But of course, today I am not going to speak about everything. We all know how the definition of the child by the Convention on the Rights of the Child looks like. I would like to stress that the Czech legal order, I mean civil code and other codes, don't define the child. Why? Because the Convention on the Rights of the Child is directly applicable, and simply the catalogue of the rights of the child is directly applicable as well. The Convention has been binding, has been part of the legal order of Czech Republic or Czechoslovakia since 1991. And has priority. And I must stress that thanks to the Convention on the Rights of the Child, a lot of acts were amended and new acts were passed at the beginning of 90s. And I might say simply that the Czech family law is child-centered. And here you can see what we consider the civil status of the natural person. So the civil status, according to the Czech law, is done by the name and surname, legal personality, legal capacity, domicile, and residence. And civil status is delivered and connected with family status. And it's very important that the child has the parents. So without the parents, there wouldn't be family status. And it's very important that according to the Czech legal order, the child must be registered in the book of births, and what should be recorded, of course, names, surnames, and so on. And it's very important that the names and surnames of the child's parents must be recorded. Of course, there are some exceptions. I will speak about them later on. The child, according to the Convention, has the right to be registered and to have access to the origin, to know the rights of, to know the origin and to have access to vital register books. So here quickly, some details about legal personality of a child. There are general rules and special rules devoted to nasciturus. It means the child which is not born. The general rule says that an individual has legal personality from birth to death, and regarding the special rule, there is a presumption of legal personality, which is defined by 3 simple sentences. It means that a conceived child is considered to be already born if it suits the child's interests. Then a child is presumed to have been born alive, and if the child is not born alive, he or she is considered never to have existed. So this concept is important, for instance, for inheritance law. I will have some details later on. Now, I would like to tell you some details about legal capacity of the child, which is quite complicated. There are a few articles in the Czech Civil Code. First of all, it's regulated the age. It regulates the age of majority and full legal capacity. It stressed that the child acquires full legal capacity upon reaching the age of majority, which is the age of 18 years. And before this age, there are 2 possibilities how the child can receive full legal capacity, which is marriage, which is available from the age of 16, and granting legal capacity. I must add that these provisions are not used in practice very often. And I would like to add that during communist period, Czechoslovakia, former Czechoslovakia, had a lot of brides pregnant brides under the age of 18, and it's not reality in these days. Simply these articles are not used very often in practice, which is good for children, I would say. Here you have some details about legal capacity of the child. The section 31 regulates general capacity, partial legal capacity, and there is a presumption that the child is capable of making juridical acts which are appropriate to the intellectual and volitional maturity of the minors of his or her age. And in fact, they can be 4 situations. It's rather complicated. I give you simple examples. So if the child, for instance, is able to buy ice cream, he or she is 6 years old, yes, the child can act freely, and this act is valid. And then, of course, there can be more difficult cases, difficult acts, and the rule is that if the child is not capable, his or her legal representative must represent the child, and beside this representation by the parents with parental responsibility, we have 2 different situations. For instance, legal acts approved by the child's parents, or legal acts conditioned by the parents. And beside that, we have, as in other legal orders, special rules for special situations. For instance, criminal law, criminal liability, 15 years, termination of pregnancy, 16 years, adoption, for instance, 16 years, so the child who has a child can give consent to adoption only if the girl is older than 16 years. Then integrity, 14 years, inheritance law, disposition, mortis causa, 15 years, and so on. And the last thing, the section 36 of the Civil Code rules general incapacity exceptions, which is rather complicated. So quickly, if the parents would need approval by a court, for instance, regarding transfer of property, of course, the child are not allowed to do these transfers on his or her own. Then family status of the child. Just quickly, we have the key rule that the child's mother is the woman who gives birth to the child. It applies by operation of law. And last week, I was speaking about problems connected with motherhood. We face a reality of baby boxes. We have the Act on Hidden Motherhood. I am convinced that these realities are against the Convention on the Rights of the Child. And of course, we have reality of surrogate motherhood, and the Czech Ministry of Justice is preparing the draft for regulation of surrogate motherhood. I would like to draw your attention to the point letter E. So it's planned that this surrogacy contract could be approved by the court, and then the result would be that the intended parents will be legally recognized parents of the child. So I wonder if this draft will become law. I don't think so. And I would say that it wouldn't be in harmony with the convention. Here I have the traditional a concept of presumptions based on simply well-known concept of fatherhood. I'm not going to read it. I would just only say that a child without a father, a legal father, can give he can go to the court and claim to the father to be determined by the court, and the child is allowed to do it anytime. But the child is not allowed to deny legal fatherhood, which I consider as a problem. So the child is protected. The child has right to know his or her origin, which is very, very important, and the child has right to be registered. But I mentioned some problems which are connected to this issue. Of course, the Czech legal order regulates adoption, and it's based on the idea that it's a benefit for real or social orphans. So Czech regulation of adoption is based on Latin rule, adoptio natura imitatur, which means that in the case the child doesn't have family, has right towards the state to find a substitute family, and in the case of the minor child, it would be full adoption, and the child would be the party to the proceedings, and the consent of the child would be the most important. The child is protected mainly by the concept of parental responsibility. Here you can see what belongs to the parental responsibility. It's important that every parent is holder of parental responsibility, even minor mother or the mother with limited legal capacity. Regarding property rights of the child, I would like only to stress that the Czech legal system doesn't distinguish between children born out and in wedlock, but of course, if the child is born in wedlock, the child is protected within the scope of community property of spouses, protection of family home, and so on. And of course, it's much better than if the child is born out of wedlock. Of course, we have very well maintenance duty regulated. One thing is law in books, and another thing is bad practice, law in action, but the state tries to solve these problems. For instance, we have a very new thing, you don't pay, you don't drive, and so on. And there are many other rules regarding healthcare, labor law, and so on. And I discussed these issues in details in my written contribution. So I managed in time. Thank you very much for your attention.